Good morning, everyone. We're going to let people join us. We'll get started in just a minute. All right, good afternoon, everyone, and welcome to the Chesapeake Legal Alliance's presentation on learning land use, how you can influence local development. My name is Molly Brown, and I am an attorney at CLA and director of our Community Legal Education Center. We have a lot of ground to cover today, but before we get started, just a few notes for you. This webinar is being recorded, and the recording and the slide deck will be available online afterwards at the CLA website. That's chesapeakelegal.org. So it'll be there if you'd like to come back to this valuable information, or if you'd like to refer it to people who were unable to attend today. You should be able to find it on the website either later this afternoon or tomorrow. We have a lot of ground to cover today. We're going to be addressing as many questions as possible during the presentation. Please enter your questions into the question and answer option on your screen. If we can, we'll be answering them as we go, and then with any remaining time at the end of the hour. Anything that we don't get to during our time today, we're going to do our best to answer in a follow-up email to the presentation. With that, I'd like to tell you a little bit about who Chesapeake Legal Alliance is. CLA is a nonprofit based in Annapolis, Maryland. We offer legal services, free pro bono legal services to communities and partner organizations throughout the Chesapeake Bay watershed on behalf of a healthier bay and healthier local water quality. This particular presentation is not going to contain any legal advice, but if that is something that you or your organization does need, make sure to contact us. You can find a link for obtaining free legal help on our website. Again, that's chesapeakelegal.org. Our in-house attorneys, along with our network of volunteer attorneys who are licensed throughout the watershed, handle all sorts of legal issues, including many of the land use issues that we'll be addressing here today. Now, I'd like to introduce you to today's presenter, Russ Stevenson. Russ is CLA's founder and board chair. His career has spanned practicing law in Washington, D.C., serving as Deputy General Counsel of the Securities and Exchange Commission, serving as Senior Vice President, General Counsel to Sienna Corporation, teaching law at both Georgetown and George Washington Law Schools, and of course, his work with CLA. While serving as our board chair, he also provides our partners and community members with countless hours of pro bono legal assistance, much of which is focused on land use issues. I'm absolutely thrilled to have him here today to talk to you about how you can influence local development in your community. And with that, I'm going to hand over the presentation to Russ. Thank you so much.
Thank you very much, Molly. As Molly said, we're going to be talking about land use issues today. As you know, what happens on the land ultimately has an effect on the water, and that is particularly true of development. And I know you are here because you're interested in development. You probably have strong views about it. And I'm going to try today to help you understand how you can become involved in the development process to protect the quality of life in the environment and to make sure that the developments that you monitor follow the law. We want to be able to enhance your involvement, to help you understand the legal requirements for development, and to introduce you to some legal issues that may be useful tools for you in monitoring and perhaps challenging a development. We're going to begin by talking about the subdivision process, how it works and how you can get involved in it. And then we're going to talk about some specific legal issues. I've listed them here. We'll talk about them each as we get to them. Subdivisions are what we see on the screen. We all know what a subdivision looks like. They are called subdivisions because they are the result of subdividing one large piece of property into multiple smaller pieces of property, each one of which can be transferred separately so that you can build a house or a commercial facility on it and then sell it off. That process of subdividing property requires approvals. So we're going to talk about what those approvals are and how you can affect the process. So the subdivision process begins, from our perspective, at the time the developer holds a required pre-submission community meeting. Pre-submission is before the developer makes a submission to the Office of Planning and Zoning to approve a development. The developer has to hold a community meeting, invite members of the community nearby the development to come to the meeting and explain what the development is going to look like and what it's all about. The developer then submits what's called a sketch plan for a subdivision, or if the property's already been subdivided, a preliminary plan for site development approval to the Office of Planning and Zoning. Although it's called a sketch plan, that's really kind of a misnomer because it's really a detailed plan, including all kinds of information about what the development's going to be, including the ones we've listed here, where the stormwater management utilities are going to go, what the landscaping is going to look like, a forest stand delineation. We'll talk more about that later. If there are any bogs, a bog protection plan, the existing and proposed drainage areas, a traffic impact study, an equivalent dwelling unit worksheet, which is technical, and finally, proof that the developer has held a pre-submission community meeting. The developer then negotiates, sometimes over a period of months, with the Office of Planning and Zoning. And when they all get together on approval of the final plan, the developer submits a final plan and then must hold a community meeting on the final plan. And OPZ issues a final approval. Note that this final approval is posted on the county website within 5 days of the approval, and this is the only public notice available currently, so that if you're monitoring this development, you have to pay careful attention to what's going on the website. And here's what a sketch plan, or the plan part of it, looks like, and as you can see, it's quite detailed. Well, what can you do to participate in this process? First, get on the distribution list for notices related to development by contacting the Community and Constituent Services Office in the County Executive's Office, and get on an email list, which they publicize regularly, new development proposals. Attend the initial community meeting. Gather information about the project, decide whether you think the project has problems or whether it's an innocent project that can go ahead without challenge. When the developer files the sketch plan, go to the Office of Planning and Development and get a copy of the sketch plan and discuss it with the professionals there. They are quite good about cooperating with citizens who are interested and discussing where things stand. You may also want to know about the Development Division website, which is here. It contains an enormous amount of useful information about the development process, what developments are going on, where they stand, and so forth. You should then monitor the progress by communicating regularly with the county so that you will know when the plan is approved. In the course of that, you can let the county know of any concerns you have. The planners in the OPZ do listen, they do pay attention, they're willing to meet with you. And then attend the final community meeting to find out what's changed between the time of the preliminary community meeting and the final community meeting. And if you still have objections, you can appeal the final approval decision as within 30 days, but you only have 30 days from the time the plan is filed, the final plan is filed, to file an appeal. That's not a whole lot of time, so you've got to stay on top of things. The final approvals go to the Board of Appeals if there is an appeal. The only people who can appeal must be aggrieved people. That's a term of art in the law, meaning that the appellants sustain an injury from this development, which is different from the injury from the public at large. Unfortunately, that's a very vague standard, which is difficult to apply, but basically it means nearby property owners who can claim that their property values are going to be injured or that they are going to sustain some kind of other injury that's different from what the general public might sustain. If you don't like the decision of the Board of Appeals, it can be appealed to the courts. But in order to have standing before the courts, you have to have participated in the appeal at the Board of Appeals level. Well, what are the tools that are of particular interest? First, there's the Adequate Public Facilities Law. The Adequate Public Facilities Law is a county ordinance which says that any approval of a development must assure that the public facilities that are going to be affected by the development are adequate. And that means roads, schools, fire protection, sanitation, water and sewer. They all have to be adequate to support the development. And if they are not, the developer is going to have to do something about it to make them adequate in order to proceed with the development. The developer has to submit studies in the course of the sketch plan approval showing whether the existing facilities are adequate. Those studies usually are prepared by various consultants to the developer. And then the project is reviewed by the relevant state or county agencies, the fire department, the roads department, and so forth. So to assure that the facilities are adequate to support the development. If that is not true, the developer has to do something, either undertake a change. For example, if the roads are not adequate to support the development, the developer may have to build a new road or expand an existing road, or has to pay for mitigation so that the county or the state can fix the problem. The ultimate decision on the adequacy of public facilities is made by the relevant agency, and unfortunately it's not appealable, and there's not much chance for public involvement in that process. However, if the public facilities are inadequate, or it can be alleged that they're inadequate, that can serve as a grounds to appeal the final approval of the project. Now we come to environmental site design, a relatively new approach. It's enforced by the Office of Planning and Zoning. Not much added opportunity for citizen input. You can review the plans to see whether you're comfortable with the facilities, but you can discuss the site design with the county planners. The idea of an environmental site design, which must be employed, quote, to the maximum extent practicable, is to reduce structural practices, the kinds of stormwater ponds that you see scattered around the country, around the county, to make use of micro scale practices, things like rain gardens that will prevent runoff and not create these large stormwater ponds, which are subject to failure. The criteria for environmental site design are found in a thing called the Stormwater Manual, and there's a link to it here. It's complicated and lengthy, it probably takes an expert to be able to decipher it. Now we come to special exceptions and variances. Special exceptions are uses of a property that are permitted by the zoning code when specified standards are met. The standards are set forth in the code, and the special exception has to be approved by the administrative hearing officer. Variances allow the departure from the normal requirements of the zoning code where there are, quote, practical difficulties or, quote, unnecessary hardship to the developer. Those are unfortunately vague, difficult terms. There are special standards for variances and special exceptions in developments that involve the critical area or that involve some sort of bog. Any request for a special exception or a variance is heard by the administrative hearing officer in an informal administrative hearing. The applicant has to give notice by posting signs showing that there's going to be a hearing on the property and making a mailing, usually snail mail, to nearby property owners so that they do have notice of the fact that there's going to be a hearing. And the hearing is public. Anyone can appear and participate. You don't have to be an aggrieved citizen. You can be just an interested citizen, but they are very informal. If the administrative hearing officer approves the variance or special exception, and it's objectionable for some reason, it can be appealed to the Board of Appeals and then ultimately to the Circuit Court. But to appeal to the Circuit Court, you have to have participated in the earlier proceedings and you have to be specially aggrieved. Unless the claim is an environmental claim, in which case no special aggrievement is necessary. Again, the appeal has to be filed within 30 days of the final decision by the administrative hearing officer or the board, and those are important times to keep in mind. Now we come to the critical area law. We all know about the critical area law. It was passed by the legislature in 1984. We'll talk a little bit about what it's about, where it is, and what restrictions are involved in the critical area of development. First of all, it's an overlay, so-called, to basic zoning and planning laws. So it applies on top of any existing zoning requirements. And during the subdivision process, the developers have to show the county planners that their development complies with the critical area if any part of it lies within the critical area. If there are objections to the compliance of the critical area requirements, they have to be raised with planning and zoning. And then if the project is approved, notwithstanding those objections, that can serve as a grounds for appeal to the Board of Appeals. In general, the critical area is 1,000 feet inland from any tidal waters or tidal wetlands. Under the law, every county is responsible for mapping the critical area in the county. And there's also a so-called buffer zone, which is more or less 100 feet from the tidal waters or wetlands, in which there can be no development. Sometimes this 100 feet limit is expanded if there are steep slopes in the area or there are specific soil conditions which threaten additional erosion. There are 3 categories of land in the critical area. There is intensely developed areas, which are areas which are already developed, and they have limited natural habitat. And then there are limited development areas, LDAs, which are not as intensely developed. And then finally, there are resource conservation areas, which are areas which have not been developed at all. And the restrictions imposed by the critical area law vary depending on whether the particular site is IDA, LDA, or RCA. You can find the critical area to see whether it applies to your development by going to the Department of the Critical Area Commission's website and clicking on this slide this picture right here, which takes you to a map that looks like this, and you have to select the county, and here we've already selected Anne Arundel County. And once you've done that, you can zoom in, and here's a zoom picture, and then finally a more detailed zoom picture. You can actually identify your piece of property if you're interested, if it's in the critical area. And here we have IDA, which is in pink, LDA, limited development areas, which are in yellow, and green represents the resource conservation areas, which, as you can see, are not built out at all. The restrictions in the critical area, as I said, vary depending whether it's IDA, LDA, or RCA. In IDA, there are no particular lot coverage restrictions or other restrictions. Pollution from an impervious surface, when it's obviously already been developed, have to be reduced by 10% by any new development, and there are certain other minor restrictions. So basically not too much restriction if the area is IDA. In LDA, the permitted density is 4 houses per acre, or if the zoning classification is more intense, under that zoning classification. And you can only make use of those uses in LDA that exist and are permitted under the underlying zoning classification. RCA areas, the ones that have not been developed, have this major limitation, only 1 house per 20 acres. And there are very limited uses allowed in RCA, mostly residential and agricultural uses. And then there are a variety of activities which are prohibited in the critical area, such as transportation facilities, sludge handling, storage, solid hazardous waste collection, sanitary landfills, uses that could be particularly polluting. There are also special lot coverage requirements in the critical area, and there are special stormwater management requirements. This is the buffer. As a general rule, you can't develop at all within the buffer. And if you're going to do any disturbance of the buffer during the development, having to do with grading or cutting trees, you have to develop a buffer management plan. So much for the critical area. Now let's talk about a particularly useful tool, and particularly for large developments that involve the cutting down of a lot of trees, and that's the Forest Conservation Act. The act, which is state law, which is implemented by county law in addition, is intended to protect tree cover, and in particular to protect so-called priority forests, which are forests with large trees. In general, the Forest Conservation Act applies to any projects that involve development of 40,000 square feet or more. And the Forest Conservation Act is administered initially by the county, although the Department of Natural Resources in the state is supposed to oversee that application. The process involves the developer submitting a so-called forest stand delineation plan, which is included in the drawings submitted as part of the sketch plan. And that forest stand delineation plan has to show where the existing forest trees are, where there are steep streams and steep slopes, and including a soils map, since the nature of the soil may affect how erodible it is and whether it might involve runoff. The developer also has to submit a forest conservation plan showing what the developer plans to do to preserve existing trees and where it wants to cut trees. The plan has to show the disturbance, that is, how many trees are going to be cut, and how the developer intends to protect sensitive areas on the site, both before and after development. The developer is supposed to pay particular attention to areas adjacent to streams or wetlands, steep or erodible soils that are within or near large contiguous blocks of forest or wildlife corridors. These have to be protected unless the developer can demonstrate to the Office of Planning and Zoning that the development plan, quote, cannot reasonably be altered. Unfortunately, that is a loophole big enough to drive a truck through, and it means that the developer can always argue that they can't alter the plan without and still protect the areas they're supposed to protect. Rare or endangered species are also supposed to be protected, and those that have historical significance, and larger or so-called specimen trees are supposed to be protected. That's part of the forest conservation plan. Again, the exception to this is the developer can show that it, owing to special features of a site or other circumstances, protecting the trees would result in unwarranted hardship to an applicant. Again, a very loosey-goosey kind of loophole, but you can argue that the developer is wrong. The plan also has to talk about so-called afforestation or reforestation. Afforestation means that the developer has to plant trees, new trees, add trees, if there is not enough forest cover already on the site. So this is a good thing. And then if the plan involves clearing of trees, the developer has to do reforestation to bring the site up to a specified threshold of tree coverage. You can use the Forest Conservation Act very effectively, and it has been used in the past historically effectively, by challenging the accuracy of the forest delineation plan. That has to be done at the administrative level. It's not appealable, unfortunately. You can challenge the adequacy of the forest conservation plan, again, administratively, by talking to the folks at OPZ. But if you're still unhappy and think that the conservation plan is inadequate, you can use that as a grounds for appeal of the final approval of the subdivision. If a development plot involves a wetland, it requires, if the wetland would be disturbed or its buffer would be disturbed, that's the 100 feet surrounding the wetland, that requires a permit from the state. It may also require a permit from the Army Corps of Engineers under Section 404 of the Clean Water Act. If that is true, the application filed by the developer is submitted on one application, which is administered jointly by the State Department of the Environment and the Corps of Engineers. For non-tidal wetlands, that is basically fresh water, the state is the administering body, and to get a permit to disturb non-tidal wetlands, the applicant for the permit has to show that the project is water dependent such as a marina, for example. And to build the project, you have to have access to the non-tidal wetlands as a central element of the use that is planned. Or if it's not a water-dependent facility, if, for example, it's a residential development, then the developer has to show that there's no practicable alternative to disturbing the wetlands in order to build the development. Again, one of those loosey-goosey loopholes that can be subject to a lot of dispute and ultimately perhaps litigation. And in addition, the developer has to show that the project will minimize the impairment of the non-tidal wetlands, that it won't cause degradation of groundwaters or surface waters, and that it's consistent with the rest of the comprehensive management plan. Most tidal wetlands, these are the saltwater areas, belong to the state. You can't dredge or fill them without a license. And if anyone requests a license and there are objections to it, the objector may ask for a hearing, which is before the Board of Public Works. And the recommendation of MDE will be considered in that hearing. And generally speaking, the standard for granting the license to disturb tidal wetlands is that it's in the best interest of the state, taking into account the various ecological, economic, developmental, recreational, and aesthetic values. A rather broad and difficult to administer standard, if I say so. The Corps of Engineers permits are under the Section 404. If the waters are so-called waters of the United States, any disturbance of a wetland has to be permitted by the Corps of Engineers. What constitutes the waters of the United States is unsettled. In fact, the Supreme Court just heard a case earlier this week on that question, but it covers all tidal waters, and it covers most streams, rivers, and lakes, and wetlands that connect with them. The Corps, when considering a permit application, has to determine that the issuance of the permit is in the public interest. Here is the process. I won't belabor it. It's relatively straightforward. What you can do is to use the wetlands permit as a tool to challenge the development is to review the application, ask for a public hearing if you think you can find problems with the application, appear at the hearing and argue as to why the project doesn't meet the statutory standards for a wetlands permit. And then eventually you can appeal the license or permit if it is granted. So to sum up, here's what you can do. You can attend the initial community meeting to learn about the project, go to OPZ, review the initial sketch plan, formulate any objections to it, identify potential issues early, have discussions with OPZ about the plan, and then if there are administrative hearings involved, for example, application for a variance, participate in the administrative hearing. And then if the project is finally approved, you have to appeal the approval of the subdivision to the Board of Appeals within 30 days. Don't forget that. And if the Board of Appeals turns you down, you can appeal that decision to the Circuit Court. But please, in working on these issues, if you think you are going to need legal help, ask for it early. The number of times we get a call on Monday saying there's a hearing on Friday, can you help us to provide a lawyer to object to this hearing? Obviously, we have trouble helping with those projects. If we know early on, we can find a lawyer, identify the problems, perhaps retain an expert to assist in the challenge, and make a difference. Unless we know soon enough, however, we're probably not going to be able to help you. Well, thank you very much for your attention on this beautiful fall afternoon, the first nice afternoon in quite a while. Please go help us make a difference. And now I think we have time for some questions. Molly?
Thank you so much, Russ. That was a whole lot of information, and you did a terrific job at getting through it all. I'm very impressed. We did have a number of questions come through. The first one we addressed in the answer box, but I'm wondering if you have anything to add to it. We got several people asking about how the information that you just provided us, where it applies. So is this Maryland specific? Is this county specific, et cetera?
Well, the slides that I presented were focused on Anne Arundel County, which plays obviously a major role in this. Each county has somewhat different laws. However, the process in most of the charter counties is very similar to the ones I've described, although it may vary in details. So you can probably use this. You may have to get some help to see what the process is in PG County or Howard County or Baltimore County, but it will be similar to the ones I've described here.
Okay, terrific. And just to reemphasize what we put in the chat, if you do have a question that is county specific, please feel free to reach out to CLA and we'll see if we can put you in touch with an attorney who can help you answer that question for the specific county in which you're asking about. Another question that came up was, what if your county does not have an adequate public facilities law?
Well, then it's not a tool you can use to be available. I think in fact, most counties do have something similar to that, because obviously, if there's a very large development in a school district in which the schools are filled, for example, that's going to create a problem. And most counties are aware of this and do something to assure that developments are going to be adequately supported by fire, police, roads, schools, and so forth.
Can you appeal final plan issues decided at approval of site plan preliminary approval?
Yes. Once the plan has been approved, you have 30 days to appeal that to the Board of Appeals. And that is 9 times out of 10, the point at which you take it to a higher authority and go up to the Board of Appeals.
This question, I think, is one of the ones that we'll have to do some research on and provide in a follow-up email. But the question was, is there data that supports the effectiveness of rain gardens? Do you know anything offhand that we can provide the audience?
No, I'm afraid I am not sufficiently expert in that. I know that rain gardens have been shown to be effective. The goal in the county of environmental site design is for the development to keep all of the rainwater that falls on the project on the site and not allow it to run off anywhere else. And it takes techniques like rain gardens or other similar techniques, and I'm not an expert in this, to be able to do that. And generally the county has done, in my experience, a pretty good job of that. And there are techniques that can be used to keep the rain on site.
Okay, terrific. I think that that's one of those that we can definitely provide some more resources for if we have a minute to follow up with it. So we'll see what we can find. Thank you for that question. Are there legal requirements for environmental site design, or is it voluntary?
No, environmental site design is part of the approval process. The county planners will review the sketch plan, which includes the environmental elements of the sketch plan, to assure that they do comply with the county's handbook on environmental site design. That is, it's not a black and white process, obviously. Achieving the goal of no runoff off the site is difficult, but the good news is 10, 15 years ago, the site plan didn't address, the initial preliminary sketch plan didn't address the environmental elements. Those were added afterwards. Now the county has required that the initial sketch plan include the environmental site design elements in it so that it can be part of the review and approval process.
Can you explain grandfathering and how this applies to critical area laws?
The basic idea of grandfathering, and it applies differently for different issues, is that if a condition exists on the ground at the time a new statute is passed, which would prohibit that condition in the future, the existing condition that's already there is grandfathered and is not treated as if it's violating the law. That's the basic concept of grandfathering.
This is another one that I think that we will answer in a follow-up email. Is there a list or place to access the endangered species that can or may affect development approval or design?
There is. I don't have it at the tip of my fingers, but the state maintains a list of endangered species and threatened species, which is different from the federal list, although they're very similar.
Okay. And any development would have to meet specifications for the federal list as well, wouldn't it?
Yes,
Okay.
yes. The differences between the state list and the federal list is that the state list is slightly broader. It includes some species that may not be included in the federal list.
Okay. All right. We'll see if we can find that resource and send it out in the follow-up email as well. Is this process generally the same for developing an individual lot or for an addition to an existing home/structure?
The short answer is that building a new house, for example, on an existing lot does not require subdivision, since the lot is going to remain intact. So there, the only thing that is necessary is a building permit, well, and then a grading permit. From an environmental perspective, the grading permit is probably the most important thing. We had a case recently, you may have read a little bit about it in the newspaper, involving a site known as Mount Misery here in Anne Arundel County, really within the watershed of both the Severn and the Magathie, where the builder had been given a permit to build a house at the top of this hill, but didn't have a grading permit yet. And the slopes of the hill to get up to this site were so steep that the county finally said, even though we approved the building permit, we're not going to give you a grading permit, and so you can't build the house. That case is currently under appeal by the builder. We'll see how it turns out.
Terrific, thank you. To what agency or department is the appeal made of a wetlands issue?
It's appealed to, if it's a federal permit under the Clean Water Act, it can be appealed to a district court. If it's a state permit, it would be appealed to state court, the circuit court.
How does this information tie into mitigation projects?
Well, obviously, unfortunately, litigation is all too often the only recourse that citizens have to challenge a development that's undesirable in some way. We'd rather not litigate, but in some cases, that's the only solution. What we've tried to do this afternoon is to give you an introduction to some of the issues, most of the issues, in fact, that could support litigation, and a little bit about the process of litigation.
How about, so I think that this was I either pronounced it wrong or maybe I just didn't say it clearly enough. How about into mitigation
Into
projects?
mitigation projects.
Litigation is also interesting.
Yeah.
And I know that CLA is involved in a number of these issues right now, but the question was specific to mitigation with an M.
Well, there are different kinds of mitigation projects. There are projects that are designed to mitigate existing problems, environmental problems. For example, a living shoreline or a stream restoration project. Those, I guess, would be considered mitigation projects. They require permits too. The living shoreline, for example, is going to be built obviously in tidal waters. You're disturbing tidal waters, you need to get a permit for that. Stream restoration is usually fresh water, it's upstream. It's waters of the United States, however, and if you're going to disturb those waters, you need to get a Clean Water Act permit. And as is often the case, if you're going to cut down trees, you may need a permit under the Forest Conservation Act. Those are just two examples of mitigation projects that might involve permits that could be challenged if there's something wrong with them.
Oftentimes, CLA volunteer attorneys find themselves on the side of contesting the issuance of permits. However, with mitigation projects, that is something that CLA attorneys can help with as well. So helping get through the permitting process for mitigation projects such as stream restorations, that kind of thing, that is something that we can offer legal assistance around as well. So if that is a project that the audience, if you were thinking about moving these projects forward and you don't know where to start, you need legal assistance on it, again, we can be used as a resource in that situation.
Good, thank you, Molly, for pointing that out.
Yeah, it's
Indeed,
fun. It's fun to.
We have helped quite often people who were looking for legal advice to conduct a mitigation project of one kind or another. Yep,
absolutely. Let's see. How will OPZ, so Office of Planning and Zoning, still provide, will Office of Planning and Zoning still provide copies of the site plans? We used to be able to pay for copies, but lately I heard that a Freedom of Information form was needed. Is that true?
Unfortunately, I've heard the same thing, that if you go down there to ask for a copy of a plan, they'll ask you to fill out a a Maryland Public Information Act form. My sense is most of the time that is simply a bureaucratic step. It's a nuisance, and it may delay things a little bit, but you'll eventually get it. Why they changed that practice, I simply don't know.
Is that something that you have to pay for, Russ?
Well, the sketch plan is a big stack of paper. And particularly the drawings are not 8.5 by 11 sheets. They're plan drawings size. And yes, the county will probably, if you want a copy, the county will probably ask you to pay for it. Now, you don't have to buy the whole thing. You can pay for a limited. If you're only interested in a particular part of it, you could ask for a copy of that. And they'll usually be pretty cooperative about it. At a minimum, they're usually glad to sit down at a table with a copy of the sketch plan in front of them and flip through it with you and answer your questions about it.
Will you please address the role of the Planning Commission in approving sewer classifications prior to the subdivision, well prior to the subdivision process?
That's a complicated issue. The state does have a sewer plan, or the county has a sewer plan. I think three different tiers. They each have different requirements. And if they're going to, the county is required by the state to adopt a master sewer plan. And for obvious reasons, where the sewers are is going to have a major impact on what can be developed. And in fact, this is one of those difficult areas in which sometimes the answer to what's right is not all that clear. It is far better to have people dispose of their sewage through a sewage treatment plant than through septic systems. On the other hand, if you extend a sewer sewer treatment, sewage facilities into an area that is currently has none, you're suddenly going to be able to enable much more development than might otherwise have been the case if people had to get perk tests and so forth to install septic systems. The Planning Commission, I believe, and this is not an area I'm not terribly familiar with, I believe the Planning Commission has a role in developing the master sewer plan, but I can't tell you exactly what that is. It doesn't get, once it has been established, it doesn't get modified that often.
Where are APFO, adequate public facilities ordinance standards / criteria posted in sufficient detail that activists can point them out to county decision makers? The question goes on to say, in Calvert County, a county official modified APFO to benefit developers at the cost of residents, and it has been difficult to point to an authoritative source to counter those charges.
That's a good question. It depends. Each of the different kinds of facility have different requirements. Obviously, what's adequate in terms of schools has nothing to do with what's adequate in terms of roads or what's adequate in terms of fire protection or public safety. And you'd have to go to the relevant agency to see. For example, the school board decides what's adequate for schools. The highway department, state or county, decides what's adequate in terms of the roads and so forth. So you'd have to go to those agencies to see what standards they apply and whether those standards are written or not.
It often seems that public input in zoning hearings is ignored. How can we provide input that can make a difference? How often is the appeals process successful? Can you give some examples?
That's a good question and a difficult one. I will say, and I speak now as a lawyer who's been practicing law in one form or another for over 50 years. We lawyers talk a lot about process. And in my experience, and I think most lawyers would tell you this, if the process for making a public decision is a good one, you are far more likely to get good results. It doesn't mean you always get the results you want, but from the beginning to the end, if it's a sound process, and the processes we've been talking about here are mostly work fairly well, it gives citizens an opportunity to highlight problems in the course of the process, and that often results in changes in the project. I can give you one really good example of that, and that is the so-called Crystal Springs development, which has been much in the papers over the last several years. That project is far better today, now that it's finally been approved, than it would have been had the initial plans been allowed to proceed. Now, that process involved both legal processes and public relations processes. And public relations, I haven't mentioned public relations here because it's not really technically a legal issue, but public relations can be used sometimes to push development in a better direction. How often do the citizens succeed in litigation? I have no statistics on that, but I can tell you that in my experience, it is not, you don't always win, but you often win. I can give you another example, which was litigation, and that's the so-called Turtle Run project down in South County, where the citizens brought an action in the Board of Appeals and won, killed the development. Partly because what the developer wanted to do violated the law. And it involved, by the way, it involved grandfathering and moving lot lines around and a bunch of other stuff. But in so doing, the lawyers who were working on that case established a very valuable precedent that can be used in later cases.
That was a really wonderful win, Turtle Run.
It was. I'm pleased to say it was our volunteer lawyers who represented the citizens in that case.
Yeah. This is not a question for you, Russ, but a comment from an attendee that I think is important to read out loud. As a planner, I want to encourage everyone to find the American Planning Association Climate Change Policy Guide. This is the professional body for planning professions assessment of impact of climate change on the state planning, land use planning, and implementation. For example, recognizing that existing land use and transportation planning causes negative climate impacts, which must be changed to current realities. Thank you very much for encouraging attendees to visit that resource.
It's an excellent resource, by the way. And if you are deeply interested in this area, I encourage you to have a look at it.
We will try to put a link to that resource into the follow-up email to the presentation. Russ, can you appeal grandfathered approval when a property changes ownership or many year past zonings?
You don't speak of grandfather's approvals. You speak of an existing condition which has been grandfathered. And the answer is, I can't think of a situation in which you could attack that use and get it changed. The one exception is a non-conforming use, which is a kind of grandfathering. That is to say, a use that existed on a particular piece of property at the time the zoning code was adopted and which would not have been allowed under the new zoning code. If that use is abandoned, then the grandfathering goes away. And a new property owner will be subject to the existing zoning code. The non-conforming use goes away.
We have 1 minute left and probably 15 more questions that came in. So we'll address these, but I think the final question here that I'm reading, I think is a really nice one to end on. And we addressed it a little bit with the Turtle Run answer. But the question is, could you describe a few legal cases where the Chesapeake Legal Alliance team prevailed in court?
Yes, I think the Turtle Run case, although it was Board of Appeals, not court, is an excellent one. Let me think of see if I can recall another one. Yes, we actually won another case before the Board of Appeals involving the Early Heights Fire Department, which wanted a rezoning, and the Board of Appeals said, no, you can't have rezoning. It's in between comprehensive rezonings. There's not been a change or a mistake in the existing zoning, and therefore you can't get your rezoning appeal approved. I can't think of any others right offhand, but I know we've won many others like that. Maybe Molly, you might want to talk about the Talbot County case.
So in the interest of time, what I'm going to do is point attendees to our website and to our CLA news. We have we track and publish all of the information about our wins and the cases that we are currently involved in, so that you can keep an eye on the cases that we are currently involved in and our wins in the past. So that you can see the really amazing work that we do. You can also, again, go to the CLA website, chesapeakelegal.org, to be able to request legal assistance if you have an issue in which you need pro bono legal help, free legal help. And there's also, of course, the donation button there if you want to help. Us continue to do this really amazing work that we do. Russ, I am so appreciative of your time, as is the entire CLA team. Thank you for putting on this really amazing presentation. We had a tremendous number of people interested in it and showed up to see you this afternoon. And again, this will be available online along with the slide deck. And we will be sending out a follow-up email with additional resources and answers to the questions that we didn't get to answer today.
Thank you, Molly, and thank all of you for attending. And we look forward to working with you in the future.
Thank you so much, everyone. Have a wonderful afternoon.